It's July 31st of 2026, and this is the Court Gallery. Today we kick things off with a man who claims he's an unsuccessful over-the-road trucker, but his vague answers about who he works for and how he gets paid leave the judge completely unconvinced. Then, we watch a judge run out of patience with a plaintiff's attorney who has repeatedly ignored a direct order to schedule mediation, making it clear the next oversight will end the case. And finally, a military veteran facing presumptive prison hopes his service record and commitment to treatment will earn him a rare second chance from Judge Rickey. But with the judge expressing great hesitation, we'll have to see if he gets probation or a prison cell. All that and more starts right now.
Recall the matter of David Barber and Scarlett Lick, file 15-15751. Ms. Spillane, I believe that may be Ms. Krause's case. All right. Mr. Barber, why weren't you present earlier in court at the appropriate time?
I was in the wrong meeting. I was in the magistrate meeting. I had to call the county court clerk to make sure that I had your Zoom meeting. So when I was signed in, I took a screenshot that I was signed in, but I was just signed into the wrong meeting, Your Honor.
All right. Ms. Krause, can you update me on this matter?
Yes, this hearing was adjourned from June 17th. To appear today in front of Your Honor to further address contempt as payments have not been made as ordered. The plaintiff has failed to submit documentation as ordered. The plaintiff monthly support obligation is $592 with an arrears balance of $4,132. The last payment that was received was in March of this year in the amount of $1,500. There was a previous hearing in front of the referee when the medical documentation was discussed that it was not provided and still has not been provided even at the most recent evidentiary hearing.
Mr. Barber, what's going on with you not making your payments and not submitting your documentation?
I have returned the documents to Pond Lee Hockey, and the documents were also submitted to the friend of the court, so I kind of object to what she is saying. I'm not sure why the documents haven't been able to produce the documents when I have turned in those documents.
How did you do that?
I'm waiting for the letter from the mail.
I don't understand what you're trying to tell me. The question was, how did you submit the documents to the friend of the court?
They were mailed in.
So do you have proof of that? How did you mail them in? Did you just use ordinary postal delivery, or did you do a certified mail? Or what did you do?
It was just a postal delivery.
So do you have a cover letter or anything that you can show that shows a date on it that says this is when I did that?
Not currently in front of me.
Well, do you have access to that, such a thing?
Excuse me?
Do you have such a letter? I know you don't say you don't have it in front of you, but did you actually do a cover letter with a date on it that shows when you sent the mail to the friend of the court?
Yeah, can I have the letter fax from Pond Lee Hockey? That's my attorney that's going for my disability.
Your Honor, he did provide the disability application at the evidentiary hearing, but what he did not bring and what was indicated by the referee was the medical needs verification, which he indicated he had, but he did not bring it. And the referee had indicated multiple ways that he could submit that on the June 17th hearing.
So, Mr. Barber, did you submit that medical needs verification form to the friend of the court?
I'll take it. I'll find it right there, and I'll resubmit it personally today, Your Honor.
That's a great idea.
If that's what needs to be, I have the medical documentation in my hand and everything. So,
All right, let's get that done. When was the referee hearing, Ms. Kraus?
It was on June 17th. It was a motion hearing. I believe it was in regards to parenting time, but when the case was called earlier this morning, you had indicated to contact probation about work that was reported, so maybe he can verify that information. I will still contact probation, but he's here and maybe we can see what's going on.
All right, Mr. Barber, are you working?
I'm not working currently, Your Honor. I'm just kind of helping mom out and friends out and stuff. And I'm trying to take in, I'm waiting for my brother to take and get some work going on.
I believe we had, when you were failed to appear, Ms. Izzet was here and she indicated that she believed that you were working as an over-the-road trucker.
Yeah, I'm not very successful quite yet on that.
Well, are you doing that?
I'm just helping a friend out, Your Honor. So
The question was, are you doing work as an over-the-road trucker?
I've been trying a little bit, and I'm just not successful yet. I'm trying to get my paperwork in order for that also.
What does not successful mean?
I just haven't been able to produce any kind of real money at it yet.
Who are you working for?
I was working with a friend of mine from high school. He's been a trucker before. And now I'm kind of at odds. Huh?
I asked if you could be any more vague. Who are you working for?
His name's Harley. He's from Colorado. He's a friend of mine from high school in Colorado. He was a trucker before, and I'm just trying to gain pointers and insights on that there, and trying to get this stuff figured out.
So, are you driving truck?
I tried to drive truck, but I don't have all my paperwork in order to drive. I'm still in the process of getting things going like that.
So what did you tell your probation and parole officer you were doing?
Driving truck, and I'm trying to.
If you reported to him you're driving truck, why can't you tell me that you're driving truck?
I'm trying to make sure that I get everything in the licensing and everything straight.
So how many routes have you gone out and done?
couple.
What time period?
Excuse me?
In what time period?
Couple of weeks ago. Just a couple weeks ago.
So have you been paid?
Not entirely. I got.
What does that mean?
Well, I got money to do the job, but I didn't really get money for an actual payment yet. I got fuel money to do the job.
Are you trying to tell me that you're working for free?
I'm not successful. I haven't been a success yet, and I haven't made any real kind of success at it yet.
Why would this company pay you for your fuel and not pay you for your time driving?
It's still in the process of getting paid, trying to get paid for it, and I'm at odds with them also.
Mr. Barber, you're making it really hard to believe what you're telling me. Do you have some documentation from this company about the runs that you've made and about what is owed to you?
I can get some of that paperwork.
You're going to need to submit all of that documentation for all of the runs that you've made to the friend of the court so that they know what you're doing. Anytime that you're employed, whether you get paid for it immediately or not, you're required to turn that information into the friend of the court. Are you aware of that?
Okay. Yes, Your Honor, I am currently aware of that now.
So I expect within the next 3 days, well, if you're gonna run the paperwork to the friend of the court on your other matter, you can run the paperwork for your work to the friend of the court today as well. So let's get that in within 48 hours, either today or Monday. I need to see your paperwork on both your employment and your medical request into the friend of the court's office here in Otsego County. Do you understand that?
Yes, Your Honor.
If it's not here, I'm going to hold you in contempt of court. Do you understand that?
What is contempt of court?
That means I can send you to jail.
Okay.
Do you understand how serious this is now?
Yes, sir.
All right. The paperwork for your medical claim and the paperwork on your business with the trucking, all of it needs to be at the friend of the court's office either today or by Monday at close of business. Any questions about that?
No, sir, Your Honor. I do have a question of why I'm not being able to see my son, and I'm a great dad, and I'm trying to do the right thing, and the court is kind of disregarding my rights as a father on that matter.
Have you filed a motion about that?
I haven't got the transcripts back from the proceeding from the referee hearing yet, which proves many things.
Well, how is the court disregarding it if you haven't filed your motion yet?
I'm not really good with paperwork. And
the court can't do anything until you file a motion.
Say that again, please, Your Honor.
I said the court can't do anything until you file a motion and we have a hearing.
Right. I believe I attempted to file a few motions before, and that was the purpose of the referee. And at the referee hearing,
Well, it doesn't sound like you're being disregarded at this point if the referee had a hearing on it. I'm sorry, I'm not able to hear you now, Mr. Barber.
Huh?
On your phone ringing.
Yeah, my phone was ringing. It was a spam call.
All right, so if you're going to do something about your parenting time, you need to contact a friend of the court, or you need to file a new motion. But there's nothing in front of me today about that. This is all on child support. You have any other questions, Mr.?
Yes, sir, Your Honor.
So, go ahead, sir.
What was the documents that the other party was supposed to produce?
The documents that you're supposed to produce are your medical records, that verification of medical form, and you're supposed to submit your new trucking employment documentation to the friend of the court today or Monday. That's the last chance you're going to have to do that. What else do you have a question about?
I was referring to the other party of Scarlett and what she was supposed to submit.
Ms. Kraus, is there any other documentation that's supposed to be submitted by the other party?
I'm not familiar with what he's talking about. I believe today's hearing was just for the show cause. I'm not aware of anything from the June 17th hearing. I don't know if he's referencing that in front of the referee.
Okay, Mr. Barber, I'm not the referee. I wasn't present at the referee hearing, so I don't know what you're talking about.
Yes, sir. Understood.
Yeah, if you have questions about it, that would be something to submit to the friend of the court's office so the referee can deal with it.
Okay, so you're
Anything else
not
today,
aware
sir?
So, and Your Honor, you were not aware of anything, documents that she was supposed to produce?
I just told you that I was not at the referee hearing, so I would not be aware of that.
Correct. Correct, Your Honor.
Do you have any other questions, Mr. Barber?
No, sir.
All right, that's all for today. Make sure you get your paperwork into the friend of the court by Monday.
Court calls Stewart v. Thornton, 26-1703.
Mr. Thornton is at the podium along with his attorney, Ms. Amy Lou Husted, who is the Deputy Director of the Public Defender's Office. Mr. Kerner is present, our elected prosecutor, along with Agent Rolfe from the Michigan Department of Corrections. Mr. Thornton was before the court last on June 11th of the year 2026, and on that date, he pled guilty to attempted retail fraud, first degree. As a result of that plea-based conviction, the Michigan Department of Corrections did prepare a pre-sentence investigation report, a sentencing information report distributed to the parties and to the court. Ms. Husted, on behalf of Mr. Thornton, had submitted a number of letters of support, and that was received by the court and reviewed as well. Mr. Thornton, would you raise your right hand with me? Do you promise that you will tell the truth, the whole truth, nothing but the truth, so help you God?
Sure.
Thank you. You may put your hand down. Mr. Thornton, have you had a chance to review the pre-sentence investigation report?
I have, Your Honor.
And your attorney, Ms. Husted, did she make herself available to you to answer any questions you might have or address any concerns you may have about the contents of that report?
Yes, Your Honor.
As you read through it, did you find everything in it truthful and accurate?
Yes, Your Honor.
Thank you. Ms. Husted, have you had a chance to review the PSIR?
Yes, Your Honor.
Do you have any changes you'd like to see made to the body of that report?
No, Your Honor.
Thank you. Mr. Kerner, on behalf of the people, have you had a chance to review the pre-sentence investigation report?
I have.
Sir, any changes you'd like to see made to the body of that report?
None of the body.
Thank you. Agent Rolfe, please strike paragraph 31. We do not require a DNA testing fee from Mr. Thornton.
Yes, Your Honor.
Let's get back. You got that? Yes?
Yes, Your Honor.
All right, thank you. I didn't hear you. Back to the defense then, Ms. Husted, have you had a chance to review the scoring as contained within the sentencing information report?
Yes, Your Honor.
Give me scoring challenges.
Your Honor, I believe, as discussed in the guidelines conference, PRV 1 should be 25.
Mr. Kerner?
Stipulated.
Agent Rolfe?
Yes, Your Honor.
Ms. Husted?
PRV 2 should be 0.
Mr. Kerner?
Stipulated.
Agent Rolfe?
Yes, Your Honor.
And PR 5 should be 20.
Mr. Kerner,
Stipulated.
Ms. Rolfe.
Yes, Your Honor.
Very well. All those changes are sustained. Any other challenges, Ms. Houston?
No, Your Honor.
Thank you. Mr. Kerner, have you had a chance to review the scoring as contained within the sentencing information report?
I have.
Do you have any scoring challenges?
No, Your Honor.
Thank you. Do you have a victim that wishes to address the court today?
I do not.
Very well then, Ms. Houston, allocution.
Thank you, Your Honor.
You're welcome.
Your Honor, Mr. Thornton knows that he has a significant substance abuse problem with both alcohol and drugs. He has recognized that his criminality is directly related to his substance abuse disorder. Your Honor, he has taken steps to remedy that situation. He enrolled in the Salvation Army, not once, but twice. Your Honor, realizing that he needs that support in order to maintain his sobriety, that at this point, he needs that structure and accountability. Your Honor, as part of that Salvation Army program, he is dropping regularly. He was dropped as late as yesterday. Yeah, and he dropped clean. We do have that available if Your Honor would like to see it. He has also been attending AA regularly.
Yep, I have the verifications of the AA. I do.
Okay.
I do.
So, Your Honor, we would ask you to take that into consideration and draft a sentence that is focused on treatment and follow the recommendations of the Michigan Department of Corrections.
Thank you very much, Ms. Houston. Mr. Kerner for the people.
Thank you, Your Honor. I'd ask the court to fashion a sentence that focuses on punishment, deterrence, and rehabilitation. I'm not sure how successful he will be on the second go around here, Your Honor, given the fact that he was not successful the first time. Take that into consideration. Thank you.
Thank you. Mr. Thornton, this is your opportunity to address the court. What would you like to say?
Yes, Your Honor. I'd like to say that I felt a lot of shame, guilt, and remorse for things I've done during my addiction. I've been very proactive in my recovery this time around, and I'm taking steps in order to sustain long-term sobriety and also be a productive member of society. And I just ask that you take that into consideration. Thank you.
Well said. I appreciate the tie, too.
Thank you.
So I spent, a great deal of time on this file, as I do with all my files. And your attorney, diligent as she is, had provided me with letters from the Salvation Army, their representatives, all of your AA, and man, that all looks great. That all looks great. And I've been known to bend towards treatment, right? I'm treatment minded. We have drug court. We have those programs. And when I'm given documents like that, that's Mr. Thornton's going after it. He's inpatient. All the AA meetings. Man, it just looks good. It just looks so good. Then I start reviewing the PSIR. Mr. Thornton, I counted 19 convictions for retail fraud in the last few years. 19. I think, that can't be right. So I had to go there. I numbered them, with my pen, each one in the criminal history. 19. And most of them, 90% of them were in Genesee County, and they were all reduced to ordinance violations, where you just got a couple days here, a couple days there, 2 days, 5 days, 12 days, nothing significant. I don't know the circumstances behind those. I don't know what it was that you took, or I don't know what you did in preparing for the sentence, how you got the deals that you did. I don't know. But it's interesting to me that all of these Genesee County retail frauds were reduced to ordinance violation, and you haven't had any consequences. Not until you ran into Saginaw County and Frankenmuth. And there they got you. You did 180 days for the retail fraud. Now, I don't know the circumstances. All I have is what's given me in the PSIR. And I'm thinking, man, this is not getting consequences in Genesee County. So then I start digging into your file more, and I see that you went through Salvation Army Rehab once before, but before you committed this offense here in Shiawassee County. So as I read it, somebody ordered you, or you did it on your own. You went to rehab, inpatient rehab, and the Salvation Army. You successfully completed the program, and then came to Shiawassee County and stole a bunch of stuff. That's what I see. So what I don't know is what this is going to do for you next. And what I don't want to be another court on your criminal history that had no consequences, that shows no consequences. I don't want to I don't want to be that court. Well, here he goes again. Judge Stewart, 2 days in jail, back out on the street again and stealing. I don't want to be that judge. I don't know. You can. I give you every opportunity to speak, and I should get a chance to speak uninterrupted too, shouldn't I?
Sorry, Your Honor.
Shouldn't I? I mean, I should. So I don't know if you did the rehab thing with all those other retail frauds you had. I don't know. All I know is that rehab hasn't worked for you, and you've had more retail frauds than I've never seen in my career, clumped in a capsule of time. And I just can't let you come to Shiawassee County, steal a bunch of stuff, run back to Genesee County, do a bunch of AA meetings, and come back to me and say, I shouldn't be punished because now I'm in rehab. I can't abide that. I can't. I'm sorry. I really want you to follow through with this and get your life back. I do, but there has to be a freight on this one. There just has to be. Having said all that, Mr. Thornton, you will be on probation for 2 years, and I can't even supervise you, right? I can't even have my people whom I trust watch you and monitor you. I love my Department of Corrections. They stay in contact with me. They let me know how you're doing. There's drug court and there's things like that. I can't even keep an eye on you at all. So, once you're gone, you're gone. Genesee County probation, or in any county for that matter, they don't report to me. I'll just never know. Some counties don't even drug test. They just don't. So during that course of your probation, Mr. Thornton, all the terms, did you read all the orders of probation?
Yes, Your Honor.
You read those, and if you're placed on probation, you think you can comply with all those?
Yes, Your Honor.
Thank you. There'll be some financial obligations. First and foremost, you must pay restitution in the amount of $1,177 to Home Depot. That comes first and foremost. And you were there more than once. More than once. They knew you. Oh, here comes Kyle. He's stealing again. Yeah, I know who he is. He's been here before taking our stuff. So that's paid first. Crime victims assessment in the amount of $130. A monthly supervision fee of $30. Court costs in the amount of $961 and a $68 state cost. And with guidelines of 0 to 9 months, this court orders you to spend the first 9 months of probation in the county jail. Against that sentence, you'll receive 2 days credit. You do have appellate rights. Mr. Schmidt will be along with your rights. Please initial the form acknowledging that you received them. If you'd like court-appointed counsel to assist you with the appeal, Mr. Thornton, you have 42 days from today's date to make that request. Despite the sentence, Mr. Thornton, it is my sincere hope that once you're done with your jail sentence, you get back to treatment and you stay on the road to recovery. I know that you can do it. Thank you all very much. We're going to take a very short recess before we get back to our sentencing.
All right, and we are on the record in the matter of Pamela Buck versus Tracy Kish, 2600953. And Miss Buck?
Yes, I'm trying to.
Miss Buck? Need you to unmute, please.
I'm sorry, I'm here.
Okay, thank you. Your name for the record, please.
Pam Buck.
All right,
I'm the
good morning.
landlord. Good morning.
Okay, Miss Kish. Miss Kish, please unmute. Tracy Kish, please unmute.
She was there.
She's here, ma'am. I'm just waiting for her to unmute. Okay, Miss Kish, your name for the record, please.
Tracy Kish.
Okay, and so the two of you were able to chat in a breakout room, correct?
Yes.
Yes.
Okay, has there been a resolution?
No.
Okay, and Miss Buck, how much money does Miss Kish owe, or are you just seeking to terminate the lease?
Well, she owes, as of today, $34.40, not including any late fees. Tomorrow it will be $48.40. I'm sorry.
Just
Yes?
a moment. Okay, you're saying 34, so I need you to be specific for the record. Is it $3,400 or $34?
$3,440. As of today. Tomorrow is $4,840.
Okay, when is the last time that Miss Kish paid rent?
April 1st. Well, no, it's not true. In May, she gave me 1,060.
What's the monthly rent?
1,400, but for up until July, it was 1,500. In July of 2025, she lost her job, so we just took that rent and spread it across 12 months of $100 payments. So that would have been up this July. So it's 1,500 up until August 1st.
Okay, I understand that. Okay. I'm going to ask you to both please raise your right hands. Do you solemnly swear or affirm the testimony you're about to give in this matter to be the truth, the whole truth, and nothing but the truth, Ms. Buck?
I do.
Yes.
And that what you've testified so far is the truth, correct?
Yes.
All right. Ms. Kish? Do you swear? Ms. Kish?
Yes.
Okay, very good. Thank you. All right. And so, Ms. Kish, do you agree that you owe $3,440?
Yes, I do. I do understand that I am behind on my rent. And I don't deny that. I have tried several times to work with my landlord. Back in May, I sent her $800 and she sent it right back. I have been out of work since February and have been actively looking for work.
Okay, Ms. Gish, I can appreciate that. But Ms. Buck is not responsible nor required to work with you nor allow you to stay there for non-payment of rent. Have you applied for rental assistance, ma'am?
I did, and it was denied.
Okay, and so Ms. Buck wants you to relocate, ma'am.
I'm sorry?
Ms. Buck clearly wants you to relocate because she's filed this action.
Right, but I had offered her to catch up till the end of June and then asked her if she could wait till the middle of July for July's payment. And she told me she just wanted me out of the house.
Okay, Ms. Kish, that's her right. It's her property. That is absolutely her right.
Right.
So it's unfortunate, ma'am, that you're in this financial situation. However, it's not Ms. Buck's responsibility to accommodate that. So, you don't dispute the amount that's owed?
I'm sorry, I didn't hear you.
You do not dispute that $3,440 is owed?
No.
Okay. And so, Ms. Buck, is that inclusive of court costs or is that is court costs additional?
Court cost is additional.
Okay, so what is the amount of the court costs?
So far, it's only been $73.
All right, so I'm showing a total of $3,513 when you add that in, correct?
As of today, yes, that's correct.
Okay, and so Ms. Buck, are you wanting the 10 days for that to be paid or Ms. Kish to move, or are you interested in extending that time?
I don't want to extend the time. I would, I don't understand. So if she pays it in 10 days, she gets to stay. If she doesn't pay it, she has to move?
Correct. Yes, if that's what you're doing.
Yes, the 10 days.
Okay. All right, so the court will find, after hearing, that plaintiff is entitled to recover possession of property. The amount now due and owing for unpaid rent is $3,513. If that amount is not paid or defendant does not move out on or before August 10th, plaintiff may apply for an order evicting the defendant. Additional money may be owed if damage or property occurs or rent continues to accrue. Partial payment will not prevent the court from issuing an order evicting the defendant, and no money judgment will enter at this time. You didn't request a money judgment, is that correct?
Yes.
Okay. All right, and the court will prepare this judgment and sign it.
Judge, can I ask you a question?
Potentially answered. It depends if it's advisory in nature, but go ahead.
You went a little fast through that. You said by August 10th, she will pay or I file for eviction?
You may apply for an eviction after if she is not paid or moved out by August 10th.
Okay.
Okay.
Thank you.
Thank you. Have a good day.
You too. Bye-bye.
Thank you. Okay. Okay. And now we will go on the record in the matter of JP Morgan Chase versus Christina Morrison, 2501974.
Good morning, Your Honor. J. Baig, BAIG, bar number P36820 on behalf of plaintiff.
Okay. Good morning, counsel. Where's your jacket?
Oh, sorry. Hold on.
Okay. And Ms. Morrison, is Ms. Morrison present?
Yes, I'm here.
Okay. Your name for the record, please.
Christina Morrison.
Okay. And it looks as though mediation was scheduled. Did mediation occur?
No.
I'm not sure, Your Honor. I'm covering for plaintiff's counsel.
Okay. All right. Has there been a resolution?
There hasn't. She's working with a debt settlement company, Amicor, and they're in contact with plaintiff's counsel to try to work something out. But in the meantime, what we're requesting is a judgment via our MST.
No, counsel, I'm going to let you know. No, counsel, I'm going to let you know this right now. First of all, and I understand you're just covering, so if you want to get this message back to the attorney of record, you may certainly do so. On May 29th, the parties were present, and this court ordered a mediation date to be selected by June 12th of this year because its scheduling order had not been complied with. So the court was not going to entertain any motions for summary disposition or grant a judgment when this court's order has not been complied with. So then on July 21st, I received a message from my general civil clerk that indicates that there's not been a mediation date communicated to the court yet. So I'm going to presume that that means that mediation has not been scheduled.
No, it hasn't.
So counsel, tell me why I should not dismiss this case for the lack of follow through of the court's order by plaintiff's attorney.
Well, it's probably, I know this law firm is usually on it, Your Honor. It was probably an oversight. I will make sure that they go ahead and arrange for the mediation.
Well, counsel, I can appreciate that. However, the oversight occurred back when they didn't have mediation scheduled by January. So then when they were here in court on May 29th, this court ordered what I stated it ordered. And now, yet again, they have not followed this court's order regarding mediation.
I'll leave it up to you, Your Honor.
So the court's going to, I won't dismiss the action entirely, but I'm going to dismiss the motion for summary disposition based upon the plaintiff's failure to comply with the court order and schedule mediation.
Very good. And that's a dismissal without prejudice then, Your Honor?
Yes.
All right. Thank you.
Counsel, if Ms. Morrison is working with a debt consolidation company, how is there not a resolution?
I'm not sure, Your Honor. It's according to Ms. Morrison, she's been making payments to AmeriCorps. I would say a lot of these do get worked out. Some don't. This one apparently is taking longer.
I'm going to give the parties until August 10th to select a mediation date. If there is not a mediation date selected by that date, this court will dismiss this action.
Very good, Your Honor.
Thank you. Have a good day.
Good morning again.
Good morning. Thank you all. You were all a little early. It's 8:44. We're only 1 minute early, but we're going to return to the matter of Lamp and Key property management versus Lakeisha Machina Curtis. Ms. Curtis is present here by Zoom. Also present is the property manager from Lamp and Key, which is Diana Lamont, and their attorney, Mr. Howard Bush. We were here a week ago, and we learned that the defendant was placed at this property by Keystone in November, and that the funding ran out in April, and the plaintiff is asking to have the rent paid or for the defendant to move. Rent is expensive, $1,300 a month, and there are also some late fees attached. So we determined that the rent through July was $2,650, $169.92 in court costs, for a total of $2,819.92. The defendant indicated she had sought other funding sources and was not successful. Mr. Bush, having been paid on this?
Not to my knowledge, Your Honor. I believe that the balance is still due.
Ms. Curtis, what's your position?
I got an appointment with Criminal Action Agency August the 10th, but that'll probably be too late. I don't know. I've been looking for jobs.
They may be able to
Nobody's
help
willing
you.
to hire me. Nobody have called me back, email me. Like,
It's
I checked every
tough right now.
resource to try and get help. I don't know.
I don't know either. It's a tough gig, but you can't afford to live here. You haven't paid rent in several months. August rent is about to be due tomorrow. It'll be another $1,300 behind. So the total will be over $4,000 of unpaid rent. And I don't know that any funding agency will give you that much.
I don't think so. I
Well,
don't think so. I don't think it's no funding down here where everybody keeps sending me to other people and I keep one, but I keep getting denied. So at this point, at this rate, like I'm just lost. Day before yesterday was the 5th year of my mom's passing, so like I'm not doing too well about that.
Yeah.
I don't know. My mental is not right. I don't know. I'm just a single mom trying, and I can't do nothing. Like I'm stuck. Like,
well, you're going to have to move is the answer to this. And it's hard to move when you don't have anywhere to move to and you don't have any money. But they're about to incur another month's rent through July. The rent is $2,650. As of August 1st, it will be another $1,300. This is expensive for someone that doesn't have any money.
it is, and Keystone set me up for this. This is crazy.
Well, they set them up and then they fund them for a few months and then the funding runs out and then they're just
They
left
just push
high
you
and
on
dry.
out there.
Yes, I see it multiple times a year. There isn't enough money to go around is the simple truth of it. You have 10 days from today to vacate, which we're going to call that August 10th.
Yeah, that's when I got this appointment, but I'ma just cancel
Well,
it.
they can agree to work with you. You stay in contact with this Lamont, but I would be very surprised if Community Action Agency will give you $4,000.
Yeah,
But they
I
might.
highly doubt it. They couldn't
But
help
that
me
would
in
just get you.
Riverside, so
All right.
that's why I was in this predicament in the first place, because nobody wanted to help. And then when I got put out, everybody was like, oh, this. Man, whatever.
Well, it's better than nothing. You got free rent for November, December, January, February, March, and April at $1,300 a month. That's a lot of money. So but the money just ran out. I think the hope is that people would get on their feet after a certain amount of time and be able to
Yeah,
pay the
but
rent
if I'm
themselves.
putting in application, nobody is calling me. What y'all want me to do? Go sit at their job with a gun, hire me, or I'm gonna blow you? Like, I don't know what y'all want me to do.
I
I
understand. It's
put
hard
in
to
these
find it.
applications, nobody called.
All right.
I even put one in downstairs up under me. Why they ain't call me back? They open every day.
But even so, $1,300 a month is a lot of rent for one person.
That's what you need to tell these landlords then.
Yes. All right, Miss Curtis, you got 10 days to pay $2,008.19.92. You can share this with Community Action. Stay in contact with Ms. Lamont. But the bottom line is you owe rent, you don't have any money, and it's a tough situation. All right, thank you all. Mr. Bush, you did provide a judgment and I've signed it.
Okay.
All right, Ms. Curtis, I wish you luck.
Will you note in the judgment that the rent is also due tomorrow?
Yeah, August rent. Well, it says that.
Okay.
The defendant may be liable for money damages if additional rent is owed, which is August. All right. I don't know. November, December, January, February, March, April. 6 times. Six times 1,300 is $7,800. Isn't like nobody did anything for her, but she's
Your Honor,
right. It's hard to find
just so
another
you know,
job.
this rent included.
It included what?
So high. All the utilities, the gas, electric, and water. That's why
Okay.
it's so high.
All right, well, they're not gonna pay it anymore, and I guess we'll just do the best we can. All right. You can wait a day, obviously, if Community Action is gonna give her some help, but I'd be surprised if they give her that much. All right, thank you.
Thank you, Your Honor.
The next, Miss Gales, would you come have a seat right here? Deer Creek versus Elena Gales. Except for 9:35, we're a few minutes behind. Wow, I got a bunch of people in the waiting room. Phone numbers. Anyway, are you Elena Gales?
Yes.
She's been here all morning watching the proceedings. She's heard me go through the rights. This is also a demand for non-payment of rent. Julie is here from Deer Creek. This is also a non-payment of rent case. And Mr. Rizzuto, what's the arrearage here?
Your Honor, in rent, I have $3,685.44. In utilities, I have $74.64. In court costs, I have $201.62 for a total of $3,961.70.
All right, Ms. Gales, they contend that through July, your rent is $3,688 behind. Now, tomorrow is August, so you're gonna owe another $957. So you're almost $5,000 behind in your rent. Do you have a plan here?
Yes, my daughter just started a new home health aide position where she gets paid to take care of me, which increased her funds significantly. And we'll be able to get caught up within 3 months and ahead. she was, she wrote out a statement for Deer Creek that she was gonna help me with my rent. Cause I didn't have quite enough income to cover the rent. And, then her position, employer changed. And there's a lot of red tape with state funded employment. But
Well,
within 3 months, we should be caught up and ahead.
As you heard me say, the law says I have to adjourn this matter at least 7 days.
Yes.
I'm gonna adjourn this to August 7th at 2 o'clock.
Okay.
Now, there's problems. The law says you have to pay this rent or you're subject to being evicted.
Yes.
I'm going to adjourn this matter 7 days, and when we come back, it will be August. And you're going to owe another $957. So it'll be almost $5,000. You have 10 days to pay $5,000. So that amount would be due by August 17th. They don't have to give you 3 months to get caught up on your rent. They can if they wish to. They don't have to ask for the writ of eviction within 10 days. They have 56 days to ask for it and 56 more to serve it. But the law says you have to pay the rent within 10 days or you're subject to being evicted. And that 10 days is going to start on August 7th. So you need to go in and see management and see what their position is.
Okay.
You need to go in and see your manager. They can agree to work with you on some sort of plan to get caught up on your rent, but they don't have to. By the letter of the law, you have to pay the entire amount of the rent within 10 days or you're subject to being evicted. And if you get evicted, then you can't get in anywhere else.
Right.
Again, you could benefit from a consultation from legal aid, but at the very minimum, I would direct you to go in and see Julie at the office and see if they can agree on something that would allow you to have a period to get caught up on this.
Okay.
Mr. Rizzuto, you got anything to add?
I just would note that in our file, we have also received some lease violation notices. So just to add that, to let Ms. Gales know, something else she may want to address moving forward.
What kind of violation?
So I have one from 6/10 that notes failure to maintain unit in a clean and sanitary condition. And then I have one from July 22nd, which also mentions the failure to maintain unit in a clean and sanitary condition, as well as allowing unauthorized persons to live in the unit.
Is that your daughter?
My home health aide, and when we first moved in, they knew that she would be there. And he said, Marshall,
well, you
the
need to
leasing
contact
manager,
legal
said to
aid.
add her at the end.
She's not on the lease.
No, he said to add her after I got moved in.
Well, she's not on it presently. There's apparently, there's a sanitary issues and, there's a lot going on here. You could benefit from a contact with legal aid. According to them, she's living there off book. Your rent is calculated based on one tenant and one source of income.
Right.
If your daughter is in there and she's not on the lease, and then they put her on the lease and they add her income, it may change your monthly rent. So there's a lot going on here. So my advice is the same. I would recommend that you contact legal aid. They're not here today, but also that you talk to your manager. Right now, your daughter's not on the lease.
Right.
And she's not entitled to live there.
Well, we went to add her onto it like they told us to do, and they said we couldn't do it till March.
Well,
So they were
August
aware
now.
she's there.
Well, it's not March. We had it March, April, May, June, July, and now August.
They said we can't add her to the following March.
Oh, till next March.
Right,
Well, that means she can't live there.
right, okay,
All right, well, you're gonna have to address those issues.
okay.
All right, Ms. Gales, I'll see you next Friday afternoon at 2 o'clock. You're welcome to come here to the courthouse just like you did here today.
Okay,
Thank you.
thank you so much.
Hey, Marvin, Dante Perkins. There's two cases.
Right. We're on a bond hearing, you know.
Is that what we're doing?
Yes, sir. I have one witness to be shooting, but I have.
Okay, where is he in custody? All right, take care of Dante and Rife, you've got some things next. All right, these are not motions to revoke probation. These are new cases.
New cases.
What? Two cases are called 26 CR 975 and 978, the state of Texas versus Dante Perkins. Is that you?
Yes, sir.
Present with your attorney, Mr. Lewis, and the state's prosecutor is here. You were charged in each of these cases with the similar type of offense, deadly conduct, discharging a firearm. In 975, it's alleged you committed that offense on or about July 5th of 2025 in Jefferson County by discharging a firearm at or in the direction of a habitation, a home. Namely, discharging during evening hours in the front yard of a neighborhood surrounded by several homes. And that's a third-degree felony if convicted, which carries with it up to 10 years in prison. But the hits did not stop. Then this is 26 CR 978 alleges that about 9 months later, March 15th of this year, in Jefferson County, Texas, you are charged with discharging a firearm at or in the direction of some individuals. That's another third-degree felony, which carries with it up to 10 years in prison. So you're looking at a total of up to 20 years in prison. Do you understand?
Yes, sir.
But what are his bonds now?
His bond in 0978 is set at 500,000. And on 0975 is set at 100,000.
All right. The court has a copy of a public safety report of the defendant. And I'm looking at prior criminal history. They're reflecting, let's see, in history, showing an arrest date on 3/16/26 for deadly conduct, and it was filed as a misdemeanor class A. I just don't think that went anywhere. Because I'm looking at the indictment in 26 CR 978, which alleges on or about March 15th.
Yes, sir.
That is alleged he committed deadly conduct, and that's the indictment in 978, which I guess is what yes, the misdemeanor must not have been filed, and then the felony was later solved. Then there is nothing about the July 5th deadly conduct here in the July 5th of 25 in the public safety report, strangely enough. But then we do see an evading arrest and detention, a misdemeanor, where he was put on probation for 6 months, and that probation expired. What this shows in the public safety report. I don't see a prior felony conviction.
No, he doesn't have any prior felonies.
But what? Oh, I think I understand. All right. The first event in time July 5th, 2025, from 26 CR 975. By the way, both of these indictments were handed up by the grand jury on May 20th of this year. So a couple months ago. And in this first indictment on or about July 5th of 2025, the law enforcement receives information that the defendant and two others were firing weapons in and around neighborhood homes. And not only do they hear about that from other witnesses, but they have a video showing him doing it. Thereafter, on March 15th of 2026, the defendant is at Rogers Park and multiple shots were fired in Rogers Park, which was life-threatening to homes and others. And apparently, this defendant was among others who were discharging the firearms at that location. So the defendant is charged with deadly conduct, two third-degree felonies. Go ahead, Mr. Lewis.
Judge, this time I call Terrence Perkins.
Raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Go ahead, Markham.
Mr. Perkins, will you state your full name for the record? Terrence Perkins.
Yeah, I can't hear you.
You heard Perkins?
She has to take everything down.
Yeah.
Thank you.
Yeah, she got to take it down. Okay. Now, for us, my client, the defendant, Dante Perkins, what is your relationship to him, this father? And where do you currently reside?
12730 First Street, Columbia, Texas.
Now, if the bond is able to be reduced where y'all can bond him out, is that where he would be residing?
Yes, sir.
Okay. Who else lives at that home?
His mother, his brother, his sister.
Okay. Typically, what is your work schedule like? Just to kind of put that out.
My work schedule, I work night shifts from 4:30 p.m. to 3 a.m.
Okay. Now, even with that, is there normally someone there to supervise or be around the home to know what's going on?
Yes, and mom.
Okay. Now, when it comes to Dante, at the time that since he's been in custody, prior to that, was he employed or working anywhere?
No, sir.
So he had no funds saved up or money saved up for that time. Does he have any type of property or anything that can be used to put the bond? Anything for collateral?
No, sir.
Okay. So who would be his co-signer or responsible for the bond?
I would be a co-signer and responsible for payments.
Okay. Now, as far as you, do you have any property or anything that can be used to secure the bond?
Only stay in.
Anything for us that could be sold or anything to secure any additional funds?
No, sir.
So any funds that will be used for the bond will come from you and family?
Yes, sir.
Okay. At this time, have you been trying to secure the bond at the amount that it said?
Yes, it's called a couple of bonds, said 15,000 and other didn't even want to touch it. So that's just, I can't make that bond at this current moment. Not at that price.
Okay. And you said majority of the bonding companies said they wouldn't even touch it at the amount it said. Okay. What do you think reasonably you and the family could do as a bond amount
They're both to like 50.
Both at 50,000?
Yeah.
So it would be a current financial obligation of $100,000.
Yeah, that would be a time.
Okay. And that's something that you believe you and the family will be able to do?
Yes, sir.
Okay. I'll pass it on to you.
Mr. Perkins, did you assist in bonding Dante Perkins out in 2024 when he was charged with the evading?
Yes, ma'am.
Okay. And were you aware that he pled to that evading?
No.
Are you aware that while he was?
Wait, well, that's a fact.
Yes, sir.
You're not aware
What
that
you
your,
mean?
are you saying you're not aware that your son pleaded guilty to a crime?
Oh, okay. I didn't understand what she was saying. Said play. Yes, he didn't receive probation for that. Yeah.
Are you aware that while he was out on bond on the evading, before he pled, that first July 5th, 2025 deadly conduct charge where he was firing a weapon in the neighborhood of Euclid Street, were you aware of that offense?
I wasn't aware.
Were you aware of what occurred in Rogers Park on March 15th of 2026?
No.
So, and are you aware that both of those events occurred in the middle of the day?
I am aware of that. Seen, heard about it. Seen.
So when you talk about somebody normally there to supervise Dante, who was supposed to be supervising him while he's out firing weapons in July of 2025 and March of 2026?
So at that moment, he wasn't staying with us, but if he was released on bond, he would be on an ankle monitor. So that would restrict his movement and confine him to the home.
Who was he staying with?
He kind of back and forth from my house to his friend's house.
Did Dante graduate high school?
Yes, he did.
What year did he graduate high school?
Dante graduated 24.
How old is he?
Dante 19.
So how can you or his mom ensure that the community is safe from Dante out in the middle of the day firing weapons into our community?
So, like I said, he'll be on an ankle monitor, and if Dante does anything outside the guidelines of his bond, I'll get off the bond. So,
Did you know that Dante possessed possessed guns in the first place?
no, I didn't know that he had any guns.
So you feel that an ankle monitor is going to keep Dante from firing guns into our community more than these 2 times he's already done accused of it?
Yes, situation, I'm pretty sure Dante's heard about this lesson. What happens, he can't move around with that. So, yes, I do think it would be helpful too.
But the ankle monitor tells the monitoring company where he is. It doesn't stop him from moving around, correct?
It doesn't. They don't have one somewhere he can only be at the house and like, only go like for a job search or something like that.
So are you aware that somebody can tell him that those are the parameters, but Dante can still go and come where he chooses to?
No.
Are you aware of that?
Well, I'm just learning about that.
No further questions, Judge?
Just a quick redirect. Mr. Perkins, as far as the how long would Dante is getting custody?
From March to now, like 5 months or something like that.
Okay. Is this the longest confinement he's had?
Yes.
At his age?
Yes, it is.
At this, so do you believe that this has definitely been an eye-opening experience for him going through this?
Definitely, I do.
Okay. And do you think that an ankle monitor or additional bond conditions could be a good deterrent for him to help him follow his way?
Yes, I think that would be a great deterrent.
Okay. And just to reiterate, as you as the co-signer on the bond, you have no problem if he doesn't comply getting off the bond, or
no problem at all.
Understand that the court would have to do what they have to do
exactly
at that moment.
Yes, sir.
Okay. Pass the witness.
You don't think the probation back in 2024 should have been a deterrent?
Yeah, I feel like it should have been,
That didn't work though, did it?
Yeah, it was just it should have been a deterrent, but at the same time, I think he's been sitting in there for 5 months now. And he didn't really see the seriousness of his actions at this current moment. You know, that was, that's the guy that it was, but him sitting in the environment, I think he really sees the severity of it.
No further questions, Judge.
Okay. So are you saying he didn't see the severity of it as he was shooting up a neighborhood and then shoot? I'm speaking. You get a chance to speak. We can't speak over each other. The court is going to ask you some questions so I can clarify this. You don't think he was smart enough to figure out that shooting up a neighborhood was wrong? Thereafter, going to a park, Rogers Park, and shooting up the park.
Yes.
You don't think he couldn't figure that was wrong the first time he did it? Based upon the fact that he had been in trouble in a past experience and had been disciplined for it. Does he have any learning problems? So he should have known.
Yes.
He should have been aware. I understand. He was 17 and 18 during each of these situations. 17 on or about July 5th of 2025, when the neighborhood was shot up. And then 18 when he is at Rogers Park. And these were incidents that occurred, looks like about a year. I'm sorry, about one occurred on or about July 5th of 2025. That looks like 6:14 in the evening. And then the Rogers Park incident occurs on Sunday, March 15th. Did you look at that? At the exact same time, 6:14, according to probable cause.
I did not recognize.
What are the odds of that? It sounds like there's a time that some people get together, if this is true. What are the odds that at the exact same time, 9 months apart, this town is being shot up? Well, we're, by grace of the good Lord, I think, we didn't have a bunch of deaths here. What bothers this court is the defendant had been held accountable earlier for an offense and was placed on a form of supervision. And on this evading arrest back in 24, which was a little less than a year before he starts firing weapons in public. And he was placed on probation for 6 months, and that expired. It doesn't say the date it expired, but I presume it expired before the July 5th, 2025 incident. They were on 6 months, but the arrest date was July of 24. And it doesn't show the date that he was placed on probation for 6 months. Do you
I
know
believe it was September 10th of 2025, Judge,
that he was placed on probation?
that he was placed on 6 months deferred probation.
So that would have ended in March of
2026,
5.
March of 2026.
Stand by. When was he placed on probation? said?
September 10th of 2025. It should be on or
Oh,
about that day.
okay. It's not showing a date. It says arrest date was 7/26/24. It took him a year before he's placed on probation.
That's what I'm showing in
The date again?
history. September 10th of 2025.
So he would have been placed on probation 2 months after the shooting of the neighborhood.
Yes, sir.
And so he was on. When did his when did his probation expire? On 9/10/25. Can we find that out? The 9/10/25 probation. Please. We got a great probation office. They can figure all these things out quickly. It says that community probation expired 6 months. And if he was placed on probation on 9/10/25, that would have been somewhere about March 10th.
Ninth, yes, sir. Up at midnight on the ninth.
Is that what you're showing on the records?
Oh, she's done, I'm waiting on her to respond, but if this case expired, it would have expired at midnight on the 14th. Or 9th. Judge, I show that an order terminating the first probation was filed in the misdemeanor case on March the 16th of 2026. That's when it was filed into the case. Let me see when the judge signed it.
Say that again. Say that again, please, so everybody can hear.
Yes, sir. So the dismissal of the misdemeanor deferred probation was filed in the misdemeanor case on March the 16th of 2026. His case expired on March the 9th. The only thing I can think of is the officer didn't send the paperwork through.
All right, so it expired on March 9th, 26.
And Judge, I'll print a copy of that
Thank you.
determination.
6 days later, he's at the park shooting. The following day, his case was formally dismissed. I mean, the probation was still warm, the end of it, and it expired, but the order was not signed dismissing it until the day after he's shooting up Rogers Park. So that probation must not have been impactful. Didn't take you but a couple of days to continue your violent behavior. March 16th. By the county court of law judge. Sorry, Marvin, that doesn't help.
Understood.
That's terrible. Your relief you're requesting is flatly denied. He has shown from his history and his lack of appreciation of the seriousness of being held accountable in the first place, that violent behavior is something that he can't prevent himself from committing. So reducing his bond would only put us all in jeopardy and harm's way based upon his lack of appreciation of remediation of his conduct, in light of the fact that just days after he's finished his probation, he's doing a second set of violent shootings in Rogers Park. That this court finds reprehensible And you will be held accountable in each of these two cases. The relief you're asking is denied based upon those reasons. I find him to be a threat to the well-being of the community based upon showing these actions and these time periods. That is all.
Thank you, Judge.
This is in the District Court of Greenwood County, Kansas. Case entitled State of Kansas versus David K. Hill. It's case number 2025 CR 192. Jill Gillette appears as Greenwood County Attorney. Nika Cummings is Defense Counsel. David Hill now appears at the Greenwood County Courthouse in Eureka, Kansas, as ordered by the court. This matter comes before the court at this time for sentencing. Court's notes indicate that the defendant had appeared before this court on April the 24th. At that time, entered a plea of guilty to count 1, amended, a failure to register as an offender, a level 6 felony, and also to count 3, possession of methamphetamine, a level 5 drug felony. A pre-sentence report was ordered. Court ordered the defendant to comply with pre-sentence assessments. Departure motion was announced to be contemplated at that time, with sentencing originally set for June 25th. As the record of the court indicates, Mr. Hill did not comply with the court's directive to appear at the Greenwood County courthouse for sentencing. The court declined to impose sentence on the date originally set and rescheduled to today against the departure motion filed.
For him, he got a drug and alcohol evaluation. He's been following that. He still feels like he needs help, and he is waiting on a bed with the VA for an inpatient treatment bed, which he's hoping to find out next week. As stated in the motion, his charge that he's reporting for as a registered offender is very old, and he's shown that he's always reported where he is, what he's supposed to do, all of the things that he's supposed to. He's always reported for years and years and years. And this is a person who has a trustee for his money. So it's obvious that he's trying to do the right thing. And in this particular instance, I would say that the report of the non-reporting of his vehicle, the officer still knew where he was, and he was not really trying to hide anything. Your Honor, we would ask the court to find mercy in this case and to place him on probation at this time. He also has very good family support. His wife is present in the courtroom. They do have 3 children together.
All right, Ms. Cummings, you've addressed the failure to register as an offender, but not the second charge, the second felony in which this defendant's been convicted, possession of the dangerous street drug methamphetamine.
Yes.
Anything that you wish to present on that?
Yes, Your Honor. So he understands that he has a drug problem, and so that is why he has gone to treatment, and that is why he has a bed hopefully available very soon. He's to find out when the bed is going to be available next week with the VA.
Very well. Ms. Gillette, does your office take a position regarding the departure request, or as it's framed as a departure request?
Your Honor, part of his plea offer in this case, I do as much as I can thorough background checks when it comes to individuals coming in and looking at their charges and what their past and history is. I was aware he was a veteran. I was aware that he was had an issue with substance abuse, and I had his prior PSI pulled. I also sent that to Ms. Cummings so she would have a clear view of what his criminal history is. He was a B in his last sentencing because of sentencing change rules. One of his person crimes is an enhancement crime in his criminal history score here. We were aware he would be presumptive prison. I was given in March of 2026 his substance use disorder clinic letter from the Department of Veterans Services and Affairs. And part of my offer with Ms. Cummings was he needed to get into the VA right away. He needed to be working with them. He needed to be getting into treatment. And I know that there are programs for veterans. And he did. Ms. Cummings got this right back to me. He went and got into treatment. I think he had probably spiraled in substance use. And so it was part of our agreement to anticipate that they would file a departure as long as he was complying with all of his VA information. And I have that before me. And I think that he needs to work with his trustee and individuals who help him to keep on target with his registration and what he is needing to do for himself. And so we anticipated there would be a departure and that I would agree as long as he was doing everything with the Veterans Affairs that he needed to. And I've been given records that he is compliant with them.
Very well. Ms. Cummings, anything further you wish to present on the issue of what you consider a departure sentence in this case?
Your Honor, I would just ask the court to find substantial and compelling reasons to depart in this case.
Questioning Ms. Cummings whether a departure is actually required in this case. Is this not a case where there's a statutory optional non-prison sanction?
Your Honor, since it's a special rule, I went ahead and filed it.
Very well. I note that there are no victims or members of a victim's family present who desires to address the court in relation to the Hill sentencing. So we'll move on at this point to formal recommendations from each side regarding an appropriate sentence to be imposed in the case. We'll begin with the prosecuting attorney, Jill Gillette.
And Your Honor, just because of the question you just asked, I will let you know 6D is a presumptive prison box in and of itself outside of the special rule, and that there is an optional non-prison sanction option, but it does fall into a presumptive prison box even without the special rule that it is presumptive prison, just so the court is aware, just based on the criminal history score. My recommendation is going to be that he have a 34-month sentence as his underlying, that he have up to 15% good time credit, and that he be on 24 months post-release supervision should he have to come back before the court and be sentenced to prison. That his probation be 24 months with community corrections. He has 5 days of jail credit. He, on count 3, the possession of opiates, that he have an 11-month underlying sentence up to 20% good time credit. He would be subject to the other post-release, which is higher, and probation term, which is higher. These are recommended as 12. I don't have an objection to them being concurrent. And he needs to follow all of the conditions of community corrections on page enumerated 5 of the PSI. And I would ask that he have an extra condition that's not listed there, that he must comply with his registration completely. I believe that he's had a long talk with Ms. Cummings about his registration, and looking at his history, he did have a conviction for registration issues in his criminal history. He had one prior conviction for not getting a vehicle on his registration in Butler County, and I'm aware of that. So my preference is that he have a special condition to keep his registration current, not only because it's a part of his probation, but because it's also the law and he can be in trouble and back here again. I understand that he has a trustee appointed for him because he has financial issues. And I don't know if he has any kind of other individual that helps him. He doesn't have any restitution for regular restitution, but he does have a KBI lab fee of $400, court cost of $193, community corrections and correctional supervision fees of $125 and $120, booking and fingerprint fee. He does not have Senate Bill 123 assessment. However, in the special question pages in the journal entry on what is our page 2, under section 15, U.S. Armed Forces treatment eligibility, I believe that he does fall under that he has served in the armed forces. I don't know if that was in a combat zone, so we need to ask that question. And if he suffered any injury or the injury is connected to service in a combat zone. And does his current conviction place him in a presumptive probation box grid? Because if we can address those questions on the journal entry, it would make a difference as to possible other issues. I know that he is receiving government provided treatment that we have for many veterans through the Veterans Affairs. And I have a copy of the letter confirming his enrollment with them March 10th of 2026. He was participating 3 times a week in a substance use disorder clinic and individual counseling sessions as well to deal with his individual needs. And he was motivated at that time. So, and I did have a list of his and a copy of his individual times he had been going to his clinic and his it's actually 13-page evaluation. So I do know that he is taking care of his Veterans Affairs stuff up until the time of plea and is scheduled to go into an inpatient treatment with Veterans Administration. I know those beds are very hard to get. We'd ask the court to inquire pursuant to Robinson as to his bids, attorney and application fee. And there is that special rule we talked about earlier in this case. And I think that is the bulk of my recommendations, Your Honor. If I think of something else, if it comes to me, I'll let you know.
I have no doubt that you will. Ms. Cummings, are you appointed or retained?
Retained.
Very well. I think that addresses the bids question. And I'll also note, Ms. Gillette, that I think that the officer made a specific recommendation on probation conditions regarding the offender registration requirements and directing compliance as a condition of probation. So, all right. Having received the prosecutor's recommendations, I'll turn to the defense. Ms. Cummings, what are your specific recommendations regarding an appropriate sentence?
Asking for the mitigated number of 32 months to run concurrent with the other charge. And we're asking that he be placed on probation for a 24-month period. And if he were to complete a year and without any bad UAs and after paying everything off, to have the opportunity to be released early.
All right. Very well. Anything else, Ms. Cummings?
No, Your Honor.
All right. Mr. Hill, at this time, the court will address you personally, and I'll ask you, do you have any statements that you wish to make in mitigation of punishment or anything further that you personally would like to present to the court? Speak up, Mr. Hill.
He's going to have to move over a little bit towards the mic.
my, I was discharged for personality disorders incurred in the line of duty.
And
Uh,
he saw his,
my fiance get, I saw my fiance die in front of me. But while I was on duty. But what I was going to say was that I'm hopeful for mercy in this case. But either way, I'm grateful that to have been in this situation. I was avoiding a lot of my problems and just kind of going through life without standing for anything anymore. And this has sort of woken me back up to the fact that I need to face my problems and handle them before they handle me. So I'd like to thank the court for everything. And that's really all I've got to say.
Very well, Mr. Hill. The court will pronounce sentence in this case at this time. Court hereby establishes count 1 as the base sentence in this case for the offense of violation of the Kansas Offender Registration Act, a severity level 6 person, non-drug felony on which the defendant has a criminal history score of D, thus placing him in grid box 6D. The court hereby sentences the defendant to the standard term of 34 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 15% of good time credit and would be subject to 24 months of post-release supervision. On that count, the court imposes no fine. Regarding the additional offense, a possession of methamphetamine, a severity level 5 drug, non-person felony, in which the defendant has a criminal history score of I, thus placing him in grid box 5 drug I. The court hereby sentences the defendant to a term of 11 months in the custody of the Secretary of Corrections. On that sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. The court does run that count, however, concurrently with the time imposed on count 1. So essentially, what you have here is a 15% good time credit, Mr. Hill, and a 24-month post-release supervision duration connected with your primary sentence in the case. No fine is imposed in relation to count 2. The court notes that pursuant to special rule and because of his placement on the grid, this is a presumptive prison case under Kansas law. The issue before the court this morning is, should this court deviate from the statutory presumption in this case and impose a non-prison sanction under the facts and circumstances of this case? And quite frankly, Mr. Hill, I have great hesitation in doing so. Number one, you couldn't even follow a simple direction as to where to appear for your original sentencing in the case, which does raise the issue in the mind of the court. Can you follow detailed probation conditions if you're given that opportunity or not? Can you complete a treatment program that will have requirements and attendance requirements in the case? Can you do these things on your own, or are your problems or your attitude so profoundly disturbing that you can't complete and that you might as well do your prison time in the case? That's the Hill. Are you a good candidate to release back into the community, or should you just do the presumptive prison sentence in the case? I do understand, Mr. Hill, that you do have service in the United States military that undoubtedly caused trauma based on what has been presented to the court. I certainly sympathize with that, but you are a convicted sex offender, You do have a registration requirement. You've understood that. You've complied with it substantially for a period of years, but you're not allowed, just because you're a veteran, to get a free pass on any offender registration requirements under Kansas law. And what is particularly disturbing here, this isn't just an offender registration violation case, Mr. Hill. This is also, again, possession of a dangerous street drug, methamphetamine, which in this court's experience has ruined, not assisted, but ruined many lives. And yet you elect to associate yourself with this dangerous drug to deal with whatever problems you have. And even someone with military service, even a distinguished United States veteran, isn't entitled to violate Kansas drug laws. You know this, but you were willing to take that chance. So again, I think you can understand the struggle this court has as to whether you should be granted the special privilege or the special exception of departure, which needs to be based on substantial and compelling reasons. But you have done one thing, Mr. Hill, that you absolutely, as a necessity, needed to do, and that is to seek treatment in the case. And apparently that you have a commitment to not only enter treatment, but to also participate successfully in it. The court has taken this into account. And the court does find that under the facts and circumstances of this case, it is appropriate for this court to grant a dispositional departure on this presumptive prison crime in count one. And the court will grant the defendant 24 months reporting probation to be supervised by community corrections. The defendant must observe all laws, report to an officer as directed. You shall not possess or consume alcohol or illegal drugs, Mr. Hill. At your supervising officers and at your own expense, submit to random breath, blood, and urinalysis testing. Perform community service work pursuant to any program requirements. Notify your supervising officer of any changes in your employment status, residence, telephone number, or email address within 48 hours of any such change taking place. You shall have no contact with disreputable characters and places. In your case, Mr. Hill, except for a treatment setting, you're not to be around anybody who might be able to supply you with methamphetamine or any other illegal drug. That is the disreputable character or place, at least in primary part, that we're talking about. You shall continue to register as an offender pursuant to the Kansas Offender Registration Act, pursuant to already existing requirements. You shall abide by any curfew or travel restrictions imposed by your officer, not have in your possession firearms or dangerous weapons. And community corrections is authorized to require the defendant to meaningfully participate in the MRT program. The defendant is assessed $193 docket fee, community corrections fee, correctional supervision fee for a felony, and a booking and fingerprint fee. Mr. Hill, I'm not sure exactly what your current financial resources are or your ability to pay. I do want you to get set up on a regular and consistent payment plan, starting with the calendar month of August. I'm contemplating at this point $75 a month minimum. Is that something you can commit to doing, Mr. Hill? Furthermore, Mr. Hill, while the court has struggled with the issue of you being incarcerated in prison, this court is not inclined to simply release you on probation today. This court is empowered under Kansas law to impose up to 60 days in jail as a condition of probation, and the court believes that that's appropriate to do here. This lesson needs to be reinforced with you, Mr. Hill, that there will be serious implications and accountability for violation of offender registration laws or drug laws in the state of Kansas. And the court will order you to into custody right now to serve the remainder of 60 days in the county jail of Greenwood County. I do note you have 5 days jail time credit, which I will credit against that 60-day sentence. So you're to serve 55 more days in jail before being released on probation, and then hopefully there will still be a bed opportunity for any inpatient treatment that may be recommended or appropriate for you at that point. Certainly, you'll be in a position of sobriety, I presume, at the end of that 55-day period. And the court has elected to impose a relatively short, in comparison, jail sentence in this case as compared to a Department of Corrections prison sentence under the facts and circumstances of the case. The court's already dealt with the issue of jail time credit. I'll again remind the defendant of his ongoing obligation to register as an offender under the Kansas Registration Act as his previous conviction for a sex offense. At some point in the future, Mr. Hill, you may have the right to seek expungement of one or more of these offenses. Certain statutory limitations do apply. If you have any questions about your right to someday seek expungement, you can address those to a lawyer and I'm sure get your questions answered. Under certain circumstances, a criminal defendant in Kansas may have the right to appeal their convictions to an appellate court having jurisdiction. And if they are unable to pay the cost of an appeal, a defendant may request the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, you, the defendant, Mr. Hill, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Greenwood County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. All right, Ms. Gillette, I think I've covered most of the things necessary.
I heard you say all the fees except for the KBI lab fee, and you may have said it, but it goes so fast that sometimes I miss it.
Was KBI lab fee indicated on the pre-sentence report?
It was not, but this is a KBI lab case.
Is that correct, Ms. Cummings? Was a KBI lab report done?
Yes.
Okay, very well. That will be assessed in the amount of $400. Anything else, Ms. Gillette?
That was all I had, Judge.
All right.
Your Honor.
Ms. Cummings?
I need to do some research on whether or not he lose his VA benefits for being in custody for 55 days. But if he ends up losing it for being in custody for 55 days and it's maybe something like 30, would the court consider lowering that if that is an issue?
Sentence has already been pronounced. I don't know that I would have jurisdiction to modify a previously announced sentence of the Kansas Sentencing Guidelines Act, Ms. Cummings, but it's not the intention of the court to have him lose benefits. It's the intention of the court to have him punished for his criminal behavior and to try to reinforce the need for him to seek and complete rehabilitation efforts upon him getting out. So I hope that there's not negative financial implication. If there is, he should have thought about that before possessing methamphetamine and violating the Kansas Offender Registration Act. So I think that's the court's answer.
Thank you.
All right, and I do want to make sure that the record reflects that the court has considered, in granting the departure request, the statements that were made in the motion for departure, his seeking of treatment, the court finding the most important factor in the case, but that he did accept responsibility in this case, that it's in the best interest of this offender in the long run not to be in a prison cell, and that there was a treatment program available in this community. I think that he can enter within a reasonable amount of time, and the court is of the belief that he can successfully complete it if properly motivated. And I hope I'm right about that, Mr. Hill, and that you're not going to be back before the court on any type of sentence review in the future. I want to ultimately consider you to be one of this court's success stories, but it's up to you because it's probably not going to be easy for you. But good luck in that regard, Mr. Hill. I'm going to place the custody of Mr. Hill at this time and with the representatives of the Greenwood County Sheriff's Office so that he can serve the remaining balance of the 60-day jail sentence imposed here today. And again, according to the court's computation, he has 55 more days to do before release. All right, do any of the other professionals in the case have any questions, particularly Mr. Klossing from Community Corrections? Did you want to stay on the meeting with him for a little while, Ken, to touch base with him, or?
No, Your Honor, I will go to the jail and make contact with him personally.
Thank you. I appreciate that, Mr. Klossing. And if there's nothing further at this time.
And that is where she dropped. And that's where we stop for now, for today. But not for long. Because it is Friday. You know what Friday means? Friday means we have a big honkin' trial case coming up on Saturday. This Saturday, we have a trial with Judge Stevens, where the defendant was in jail. He was in isolation at the jail. I don't know if it was prison or jail or whatever. They had to move him from one cell to another for whatever reason. There are reasons, I don't care. He pitched a fit. He pitched a big fit. He barricaded himself in the cell. And when they went in to get him, he came barreling out with both hands wrapped up in socks and pins, like good old John Wick, and came on stabby with the good old corrections officers there. And man, oh man, we'll see. We'll hear all about that tomorrow. I'm still working on it a little bit. I'm trying to cut it down. It's a honking 7 hours long right now. I'm trying to get it down to something a little bit more manageable, maybe more like 4 or 5. We'll see. We'll see how the cookie crumbles. I don't think we need to see all the corrections officers in there, but some of the stuff is interesting stuff. I'm not gonna lie. But if you want to see the whole live thing happen, you can go check out Recovery Addict's coverage of it over there. He covered it this past week, and I watched it. I watched a good portion of it with him, and I thought it was amazing. So do want to give him credit for covering that. And oh yeah, I have a lot of people to thank here. So let's go ahead and get this thing started, shall we? Ladies and gentlemen, I want to say a hearty thank you to my mod, Rhonda. She is a longtime viewer, a great friend, and she gave a great big old super chat. Thank you so much, Rhonda. And Wendy Greek, thank you so much. Tracy, Dimmer, y'all, let's see. I gotta say, oh yeah, Tracy, the 4:45 a.m. thing, you start the new job. Congratulations on the new job, by the way. I will definitely look at dropping some stuff for you to have to watch when you're at work. You're so welcome, Denver, for, I do what I do. He says thank you for putting all this stuff together, Barry says, thank you, Wolfie, for all you do. Bring these to us same time every day and even more throughout the day. Here's a copay for the defense attorney's clients, chaos, consternation. Oh my goodness, all you people are so wonderful. Spec says, yep. Use all. Mwah! Unbiased Juror says, props, Rhonda. She's a great moderator. She is. Bat Boy is back. Another one for the Rhonda, the great moderator. I do have a sick puppy over here. So Jay Murder gave me a little bit something for the sick puppy fun. Jill Bryan, thank you so very much. Thank you. You are appreciated. Charlene Tutt, always appreciate you. Oh man, all you people. Thank you so much. I'll see you next time. I'm out. And remember, only you can take a bite out of crime. Bye! Bueller? Meow.